Hi, I'm Dr. Simone Gold. Today I'm speaking to you not just as a physician, but as an attorney and as an American deeply concerned about the future of our children and our constitutional freedoms. Three recent United States Supreme Court cases, United States versus Scrimetti, Childs v. Salazar, and Mahmoud v. Taylor, mark a major turning point in the fight for parental rights and free speech and the protection of children from state-imposed ideologues. These are not abstract legal debates. These rulings directly affect whether your child can be protected from dangerous medical procedures, whether a counselor can speak the truth, and whether you, as a parent, retain the right to guide your child's education and moral development. Let's review each of these cases and why they matter now more than ever. First, United States versus Scrimetti. In June, the Supreme Court upheld Tennessee's ban on so-called gender-affirming care for minors. Let's be really clear. We're not talking about anything affirming. We're talking about medical mutilation, puberty blockers, cross-sex hormones, and genital surgeries performed on children. The court rightly recognized that these procedures cause irreversible harm, infertility, loss of sexual function, osteoporosis, blood clots, and lifelong regret. And they struck down the Biden administration's challenge to Tennessee's law protecting children. Justice Clarence Thomas exposed the fraud behind these treatments, especially the purported experts at WPATH, the same group that admits there's literally no evidence behind their guidance. He referenced a shocking admission by WPATH, quote, that explaining fertility risks to a 14-year-old is like talking to a blank wall. Any parent knows that. This case set a critical precedent. States have the right, in fact, the duty, to protect children from irreversible harm, even when activists, including physician activists and profiteers, push pseudoscience under the guise of affirmation. And the American people are behind us. 72% oppose these procedures for minors, including the majority of Democrats. Next, Childs v. Salazar. In March, the Supreme Court agreed to hear the case challenging Colorado's minor conversion therapy law, also known as the counseling censorship law. This law prohibited licensed counselors from helping minors overcome gender confusion if it involved affirming their biological sex, even if that's what the child or the parents want. Violators face fines up to $5,000 and loss of their license. So Kaylee Childs, a Christian counselor, sued the state of Colorado, arguing that this law, not allowing her to discuss biological truth, violates her First Amendment right to free speech by censoring her ability to provide faith-aligned counseling. Colorado's law doesn't penalize counselors who encourage gender confusion, but targets only those who help children embrace their biological reality. This created a one-sided mandate, forcing counselors to affirm gender ideologues or remain silent, even when their clients sought help to detransition or cope with the aftermath of medical mutilation. The state claims counseling is conduct, not speech. Oh my God, and thus unprotected. But Childs, represented by the Alliance Defending Freedom, argues this is viewpoint discrimination. The District and 10th Circuit upheld the law, but the Supreme Court's decision to hear the case signals hope for a reversal, given their 70 to 80% reversal rate of lower court rulings overall. Childs v. Salazar, Counselor Childs, suing Colorado State, is about much more than free speech. It's about protecting children from a system that funnels them toward a profiteering-motivated medical mutilation system. By silencing counselors, Colorado ensures minors receive a gender dysphoria diagnosis, setting them on a path to irreversible procedures that generate millions for the medical industry. The case also highlights the absurdity of denying detransitioners counseling to navigate the psychological and physical fallout of these interventions. A favorable ruling for Childs could strike down similar laws in over 120 jurisdictions, restoring counselors' rights to provide ethical care and protecting children from ideological coercion. We expect a decision this fall. And finally, Let's examine Mahmoud versus Taylor, a landmark victory for parental rights decided on June 27, 2025. I was present for oral arguments on this case. In this case, Muslim and Catholic parents in Montgomery County, Maryland, sued their school board for denying them the right to opt their children out of mandatory gender ideological instruction. The books the schools are using include Pride Puppy and Intersection Allies, which introduces preschoolers to concepts like drag queens, non-binary identities, and same-sex relationships, contradicting their parents' religious beliefs. The parents didn't seek to ban these materials. They simply wanted their children to have the choice to opt out. The school board refused, and lower courts upheld the policy against the parents. The Supreme Court, in a 6-3 decision, reversed the lower courts, with Justice Alito writing that forcing children into instruction that undermines their parental religious values violates the 14th Amendment's Due Process Clause. The ruling affirmed that parents have a fundamental right to direct their children's religious upbringing, and schools cannot impose ideological indoctrination. Justice Alito noted that the school board encouraged teachers to reinforce gender ideology and reprimand dissenting children, going beyond mere exposure to coercive indoctrination. This decision is a massive win for families, children, constitutional rights. It challenges similar policies like Washington State's HB 1296, which stripped parents of access to their children's medical records. Can you imagine? And shields school employees pushing gender ideology. It also sets a precedent for cases like Foote versus Ludlow, where schools prioritize students' self-declared gender identities over parental authority. Mahmoud versus Taylor is a critical step in dismantling state efforts to sever the family unit, claim ownership over children's minds. So, what do all of these 3 cases have in common? Let's connect the significance. In Skrmetti, Childs, and Mahmoud, these are interconnected battles in a larger fight to protect children, free speech, and parental rights from government-imposed ideologies. Skrmetti upholds states' authorities to ban harmful medical procedures, ensuring children are protected from irreversible damage. Childs challenges government censorship of counselors, defending free speech and the right to provide ethical care that aligns with biological reality. Mahmoud restores parental constitutional right to shield their children, from ideological indoctrination, reinforcing the family and parental rights as the foundation of a free society. Together, these cases confront the medical-industrial complex, radical gender ideology, and state overreach, affirming that children are not state property, but individuals deserving protection. However, the fight continues. Activists and institutions, literally like the American Medical Association, are pushing back, and laws like Colorado's Kelly-Loving Act show the ongoing threat of ideological coercion. It's important to note that in all 3 of these cases, AFLDS was the largest or only physician organization to support the side of freedom, common sense, and parental rights. As Americans, we must remain vigilant, supporting legislation like Protect Children's Innocent Act, and ensure these victories translate into lasting protections for our children and freedoms. Thank you so much for standing with America's frontline doctors.